of these conditions, then one of three things can happen. I can continue your community control under the same conditions previously ordered. I could continue with additional conditions that I think are appropriate. Or the third, the most serious, is that I could terminate you from community control and then send you to prison on each of the charges for 12 months maximum consecutively for a total of 24 months. And I could fine you $2,500 in each case. Do you understand that?
Yes.
Now, do you have any questions about the allegations or what the state's alleging?
No.
Do you understand your rights to have a hearing?
Yes.
And you understand the consequences of either admitting or being found to have committed these violations if there's a hearing?
Yes.
Okay. Has anyone promised you anything or threatened you in any way to get you to admit to these allegations?
No.
All right. So, if a denial of the allegations is simply that you wish to have a hearing and have the state present evidence, but if you admit that you're admitting that those allegations are true and that you have violated the conditions of your community control, and that the court can take one of the three actions, or will take one of the three actions that I just described to you. Do you understand that?
Yes.
Is there anything you need to speak to your attorney about before we go any further?
No.
Do you have any questions about anything that I've explained to you here this afternoon?
No.
All right, then do you admit or deny the allegations that you violated Rule 2, 7, 15, and 19 as set forth in the December 17, 2021 notice?
I admit I violated them.
Thank you. All right, is there anything from the state regarding disposition?
Thank you, Your Honor. Given that this is the defendant's first violation since being placed on community control, and also given that it's clear there's an ongoing substance abuse issue here, the state would ask that you be continued on community control in order to complete residential treatment. It's my understanding that there's a bed available at the Recovery Council on Thursday of this week, also a bed available at Star on January 5th. Given that this defendant has already been to the Recovery Council, the state would ask that you be ordered to complete Star. Thank you, Your Honor.
All right, thank you, Ms. Witt.
Yes, Your Honor. As Mr. King noted, this is Jeff's first violation. We do ask the court for him to have the option again at residential treatment. It's apparent that he readily admits that he has a significant drug problem. So just ask for another chance at community control and treatment.
Anything you'd like to say, Mr. Duncan?
I'd just like to have another chance at residential treatment after I get out of bed.
Let's see. You were in residential treatment before, weren't you?
Yes.
And where was that?
I went in September 9.
Where, I said?
Oh, Kent.
Kent's place? Okay. That was last fall?
Yes.
2020 or 2021?
I went in 2020, got out January 5th, 21.
Okay. I see Ms. Sturgill's on the call. Sturgill, what's your recommendation of another stat in private residential versus a Star?
I feel that a second chance in residential with the appropriate aftercare, this time doing transitional and making sure that the aftercare completed, I think that he would, he did successfully complete once before. He came back to same people, places, and things. I think that's where things started to go wrong. So I would like to see him have another chance at residential before Star.
And this is at the Recovery Council?
Yes, sir.
Okay. All right. And it's the order of the court that the defendant be continued on community control with the additional conditions. First, he successfully complete residential treatment for TRC and aftercare. he will remain in custody until conveyed there. When did you say bed's available tomorrow?
Thursday.
Thursday, all right. So he'll remain in jail until he's conveyed there. Pay the court costs. And I'm gonna refer the matter to the drug court. I know he originally was too low for drug court on his ORAS, but I would suspect that given the relapse and the violation, that he probably will get 15. So, I'm going to have you talk with, Ms. Churchill about that, and see what you think. You have to apply for that. So, you don't have to. I'm just referring you. I want you to talk to Ms. Churchill and your probation officer, and they can explain it to you, and then you can determine whether you wish to apply for it or not. If you don't want to, that is okay. That's not going to affect what I just ordered, but I think you might be a possible candidate for that. But I'll leave that up to Ms. Churchill and the probation officer for that final recommendation. All right. Anything further from counsel?
There you go.
All right. Thank you. All right. Corey Spivey. All right, this is case number 21 CR 157, State of Ohio versus Corey Spivey. And you are Corey Spivey appearing there from the jail? I'm sorry, from you're at the forensic center?
Yeah,
Where are you?
enforcement.
Okay, down at the counseling center?
Here.
TCC?
Yeah.
All right. Now, this hearing is being conducted by Zoom due to COVID-19 protocol. Miss Weed there, if you could mute your volume so we don't get any feedback, and also you, Miss Burke, if you would please, so we don't have any problems there. All right. Mr. Spivey's attorney is Danielle Witt, appearing from her office by Zoom, and also from the prosecutor's office, Assistant Prosecutor King. The defendant is charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. This matter is, I believe, is set for a trial, but the final pre-trial is continued due to the personal family matter and of the court, and was reset for today. Now, Mr. Spivey, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to the charge of the indictment. First of all, I'll hold this up to the camera for you to take a look at it. And, can you see that says plea of guilty has your name and case number on it?
Yes.
Okay. And on page 3, there are signature lines. About a third of the way down, there's a sentence that reads, "I enter this plea voluntarily," and then immediately below that is a line with a signature defendant printed below it, and it appears to be the signature of Corey Spivey, and I'll hold that up to the camera and ask you if you see that sentence there next to my finger and that signature?
Yes.
And is that your signature?
Yes.
And when did you sign this document, Mr. Spivey?
Like 2 weeks ago.
I'm sorry?
I think it was like 2 weeks ago.
Okay, all right. And before you signed it, did you talk with your attorney about this and go over it with her?
Yes.
And did you explain everything to your satisfaction? Answer any questions you had?
Mm-hmm.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, I think so.
And you understand that by signing this agreement, if you go forward and plead guilty, there won't be a trial. The next step in your case would be a sentencing hearing.
Yes.
And are you entering into this agreement to plead guilty voluntarily?
Yes.
Now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of aggravated possession of methamphetamine, a fifth-degree felony, under 2925.11 the Ohio Revised Code, a fifth-degree felony. Further states that you understand that the maximum penalty for that, if convicted, is 12 months in prison. The minimum would be 6 months. There could be a fine of up to $2,500, and there could be a license suspension of between 6 months and 5 years. Do you understand that?
Yes.
Now, Mr. Spivey, are you facing any felony charges in any other jurisdiction?
Yes.
And where's that?
For Kent County, Kentucky.
Okay.
And, I think that's all I'm right? Oh, I got caught in Warren County. They didn't charge me with the charge. I had 14 grams of meth on me.
Okay, so possibly you could be charged in the future, maybe. Okay.
Yeah.
Well, in the event that you are convicted in this case, and if you should be sentenced to prison, and if you should be convicted in the other case, or cases and sentenced to prison, the sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes.
And are you on felony probation, community control, or post-release control?
For you guys, I am in Kent County. That's what my warrant for is for probation violation.
Okay, all right, well, I've already covered that. That falls under that first explanation then. Okay. Now, I would say this, in addition, that if you plead guilty in this case, or are found guilty, then that would be probably, I don't know what your terms are in Kentucky, but most places, conviction of a new crime while under probation or community control is a violation, which subjects that then to having the sentence imposed. You understand that?
Yes.
All right, now, under the law, Mr. Spivey, if you are sentenced to prison for this offense, if you're convicted, and you serve that prison term, once you complete that term, it is possible, as part of the sentence, that the adult parole authority would place you in what's called post-release control supervision for a period, in this case, of up to 2 years. It's possible that it's up to them. They will make that decision. The court has nothing to do with it. If they do it, you'll be supervised for a period of up to 2 years by a parole officer in the terms they set, because the court, again, has no involvement with that. And if during that period of time they determine that you have failed to comply with those conditions, then they could return you to prison. They could serve an additional period of up to 1/2 of the prison term that was imposed, which in this case, the maximum that could be would be 6 months for one or more violations. However, if you commit a new felony while under post-release control supervision, then an additional whatever sentence could be imposed by the judge in that new case. That judge could also sentence you for committing that violation, in this case, to an additional period of 1 year, or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison if you are convicted of this offense. I can impose what's called community control or probation. That means that instead of going to prison, you'd be put under the supervision of a probation officer under the term set by the judge for a period of up to 5 years. If during that period of time you're being supervised, the probation department felt that you were not compliant, they would have to file a written allegation of that with the court, provide you a copy, and then you would be entitled to have a hearing and be represented by an attorney. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to prison for 12 months and fine you $2,500. Do you understand that?
Yes.
Right now, under the law, let me back up. All right, the allegation in the charge, in the indictment, alleges that on or about March 23, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge of the 5th degree felony, aggravated possession of methamphetamine with the penalty of 12 months in prison and fine of $2,500 and a possible license suspension of 6 months and 5 years. Now, Mr. Spivey, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the nature of the offense, possible legal issues of the case, possible defenses you try to raise at trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
Yes.
Are you taking any prescription drugs?
Yes.
Okay, does that interfere with your ability to understand what's going on here today, or to tell us what your thoughts are and to understand these things?
No.
Okay. Now, have any threats been made to make you plead guilty here today?
What is it, sir?
Has anyone threatened you in any way to make you plead guilty here today?
No.
Now, the Agreement on page 2, about 2/3, 3/4 of the way down, there are a couple of sentences that are printed in bold and underlined, and then there's part of that's been stricken out that doesn't apply, so only read the part that's not been stricken out. Defendant shall enter a plea of guilty to the indictment, state defense, jointly recommend community control, the defendant be referred to drug court. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, the recommendation of sentencing is not binding on the judge, so even though there's an agreement by both parties, you should get community control. If you plead guilty, I don't have to follow that recommendation. I could, if I thought it was the right thing to do, sentence you to prison for up to 12 months and fine you $2,500 and suspend your license for 6 months to 5 years. You understand that?
Yes.
Now, do you hold any kind of a license or certification from any state agency that supervises any type of an occupational profession, like nursing or teaching or anything of that nature?
No.
Okay. Now, you have certain constitutional rights which understand before I can accept this plea from you. First, you have a right to have counsel. Ms. Witt's been appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you wish her to provide. So, if you decide that you do not want to plead guilty, Ms. Witt will continue to represent you and defend you in this charge, against this charge, including a trial if that's what you want. You understand that?
Yes.
Now, under the Constitution, Mr. Spivey, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty under your trial act. After they are selected, the evidence will be presented, they will be instructed on the law, and then they will decide by unanimous verdict, meaning all 12 have to agree on a verdict, as to whether or not the state proved your guilt or proved beyond a reasonable doubt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, and waive in this case means to give up the right to have a jury trial, and in that case, you would have what's called a court bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes.
Right now, under the Constitution, Mr. Spivey, you have the right to confront witnesses against you and to cross-examine through your attorney in open court. What that means is the witness against you have to come in court, testify in front of you, your attorney, and everyone else is present. After your attorney is done, or after the prosecutor is done asking questions of that witness, then your attorney has the right to ask questions, and that is called cross-examination. What that means is the attorney for the defendant asks questions, and that is try to bring out evidence with help your side of the case. You understand that?
Yes.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come in court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those witnesses to come to court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
And Mr. Spivey, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one could ever make you testify in the case. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it except in one situation, that is, if there is a jury trial, you cannot testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Right now, under the Constitution, Mr. Spivey, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you were indicted. In fact, under the law, you don't have to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, originally you entered the plea of not guilty. The not guilty plea denied the allegation in the indictment that you committed any crime, and it exercised or invoked all the rights that I just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegations in the indictment, admit that they're a crime, that you committed the crime, and that plea will be used to find you guilty. Now, if you plead guilty, then you waive and give up all of the rights that I have just described for you here today. not guilty plea, you invoke all of them, you have all those rights, but a guilty plea gives them up. So a guilty plea means you would be waiving or giving up your right to a jury court trial, you waive or give up your right to confront witnesses in open court, and cross-examine through your attorney, you waive or give up your right to use the power of this court to compel or force witnesses to come forth to testify for you, just like the state. You waive or give up your privilege against self-incrimination because you're the one saying you're guilty, and that guilty plea is what's used to find you guilty. You would also waive or give up your privilege against your right to be part of the state to prove your guilt and prove beyond a reasonable doubt, because if you plead guilty, the state doesn't have to prove that you're guilty. You also waive or give up any right to file an appeal that you think you could have had up to this point in the case for any alleged violations of your rights you think may have occurred. Now, if you are sentenced to the maximum sentence or under certain limited circumstances, an appeal could be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And Mr. Spivey, are you a U.S. citizen?
Yes.
Now, you have any questions about the charge or the possible penalty?
No.
Okay. Do you have any questions about the plea agreement?
No.
Do you understand?
Yes.
Do you have any questions about the constitutional rights that I've explained? Do you understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter this plea here today? You understand?
Yes.
One thing I didn't cover at the beginning of this hearing is that since we're doing this by Zoom, if you need to talk to your attorney, I can go ahead and put you in a breakout room, and you may have heard me say that to the case before, where the two of you can talk privately without anyone hearing or seeing. Do you have any reason to need to talk with your attorney?
We talked morning, prior to.
Okay, so you're okay then?
Yeah.
And I didn't ask either, but Ms. Witch, you and your client are both agreeing that this matter be conducted by Zoom, waiving in-person presence in the courtroom.
Yes, we do, Your Honor.
And you're agreeable to that as well, Mr. Spivey? That you're agreeing that appear by Zoom from at the counseling center rather than coming out here to be in person?
Yes.
Okay, thank you. I meant to cover that at the beginning, but I sometimes forget. All right. Now, is there any questions you have about anything that I've talked about here this afternoon?
No.
Then is it your decision to withdraw your non-guilty plea, plead guilty to the charge in the indictment pursuant to the terms of the plea agreement that I've just gone over with you?
Yes.
Okay, then as to the charge, which alleges that on or about March 23, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of section 2925.11 of the Ohio Revised Code, a 5th-degree felony carrying possible prison term 26 to 12 months, a possible fine of up to $2,500, and a possible license suspension of 26 months to 5 years. How do you plead? All right, thank you. All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. The plea is accepted and ordered filed. The defendant is found guilty of the charge. This matter will be referred to the probation department under the same bond. The report shall include an assessment for substance use disorder treatment and/or mental health, which the defendant is already engaged in. And the matter will be set for sentencing on February 17 at 1 o'clock p.m. The probation department, you need to contact the probation department. Mr. Balzer, are you still there? I see you turn off your camera.
You said 1 o'clock, right, sir?
Yeah, that's when the sentencing is. We'll do that by Zoom most likely. But tell you what, when we get done, go ahead and call the probation department and ask for an appointment with Mr. Fulton and tell them that you pled guilty and they need to set up a pre-sentence interview with you. They can do that. Did you already have an appointment to call in the next couple of days? Okay. Well, your case manager, I assume, sitting there with you, so just ask her to get you to a phone where you can call, and they'll make an appointment with Mr. Fulton. It won't be today, and he'll do an interview, and get information from you, and gather information from counseling center and, any other materials that might be relevant in the court making its decision as to what your sentence ought to be. All right, so anything further from counsel? All right, thank you. All right, are you Ms. Hildebrand there in the county jail? Okay. So we'll go to, Lacey Hildebrand.
Recording in progress.
Okay, this is case number 21 CR 70, State of Ohio versus Lacey K. Hildebrand. The hearing being conducted by Zoom rather than in person due to COVID-19 concerns. Well, I just lost the defendant there. Hey, Ben, she's gone, so we can call the jail down and log back in.
Recording stopped.
And then you're Katie Creed,
Yes.
okay. All right, see what happens there with the jail. If we don't get them back voluntarily, we'll go ahead and do one of these other cases. Okay, well, let's go ahead and switch us over to Carissa Purcell.
Okay. Wrong, Judge.
All right. Okay, this
Recording in progress.
is case number 21 CR 70. Oops, that's the wrong case. That's Ms. Hildebrand's case. 21 CR 176, State of Ohio versus Carissa Frankie Del Purcell. You are Carissa Frankie Del Purcell, appearing on that screen that says Evelyn Burke.
Yes, Your Honor.
All right. This hearing is being conducted by Zoom due to COVID-19 concerns. The attorney for the defendant is Daniel Witt, here in her office, representing the State of Ohio as Assistant Prosecutor Candy Kern in his office. Now, Ms. Witt, you and your client both agreed to waive the personal appearance of the defendant and allow this matter to proceed by Zoom.
We do, Your Honor.
All right. And you're in agreement with that, Ms. Purcell?
Yes, Your Honor.
All right. Now, at any time that we're having this hearing, you decide to talk to her, just let me know, and I will put the two of you into a breakout room, which is another part of the system that I don't exactly understand how it works. Nonetheless, it's just the two of you. No one else can see you or hear you. You won't be recorded. Okay?
Okay,
All right.
thank you.
All right. Now, the defendant has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred for a pre-sentence investigation. I have reviewed that. Did each of the attorneys have an opportunity to see the summary of the report?
Yes, Your Honor.
All right. Anything from the state regarding sentencing? All right. Ms. Witt, anything from the defense?
Yes, Your Honor, we do ask the court to follow the recommendation for Carissa to be granted community control as well as drug court. It's my understanding she's been doing really well in treatment. She's expected to complete just a few weeks and has plans to start a transition after that.
All right. Ms. Purcell, do you have anything you would like to say? Is it Purcell or Del Purcell? For your last name?
Purcell.
Just Purcell? Okay, and Del was part of that, or if it was,
Yeah, Dell's like, yeah, it's a part of my middle name.
okay. So yeah, you want a person that has four names, yeah.
Yeah.
My parents couldn't afford four names, so we're like, all right.
Yeah.
Now, anything that you would like to say regarding sentencing?
Yes, Your Honor. I think drug court would be a great opportunity for me to be held accountable. I need that right now. I'm doing great here at Fort Smith. This is a great program. And as well as probation took it, I would like huge transitional once I'm done, just because I don't know how to live sober, so I need to build that foundation. I serve the court as my recovery, and like drug courts, go hand in hand with that one here.
All right. Anything from anyone else? Okay. When did you complete the drug court in Clinton County?
2019, Your Honor.
Okay. Apparently you completed that and then later were found guilty of a probation violation and sent to prison.
Yeah.
You were given jail time credit, so you served everything well.
Yes.
Okay. All right. Well, Ms. Purcell, I understand that addiction is an ongoing struggle, and even for those folks who do complete drug court, that maybe that how long we're in drug court? How long are we in there? 18 months?
2 years.
2 years. Well, we have a minimum of 18 months, and most of them are averaging about 2 years. But I don't know if we've had any other persons who successfully completed before. In this situation, I am going to go ahead and place you on community control. I'm going to admit you into the drug court. And you understand that this is your request. It's not, of course, not forcing you, but you've indicated this is what you want to do. Is that correct?
Yes, Your Honor.
All right. So it's ordered the court that you be approved for the drug court docket and be sentenced to community control under the drug court docket for a period of 3 years. We're required to comply with all the program requirements that have been in the description and attachments. I believe you signed those and filed with the court. Is that correct? You signed them? Okay. All right.
Yes, Your Honor.
And I'll go over some of them. I'll cover everything that you sign is part of the conditions. First, lawyer bail, law jurisdiction, conduct yourself in law-abiding manner at all times. Report when and as directed, be truthful in all statements you make to the probation department, and allow any answer to give them about your conditions. That will include also any providers to the department and treatment team members. You must keep your supervising officer informed of your residence, place, and employment all the time, without change either, without prior permission. And again, we have restrictions on that in the drug court. You're not permitted to leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor may communicate with or can communicate with anyone who's inmate in any of those facilities without prior written permission. Now, because of your conviction, it's prohibited under both federal and state law from your owning, purchasing, buying, or having in your control or use any kind of a firearm, ammunition, or dangerous ordnance. It's also a violation of community control if you do that, as well as if you're not permitted to have any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance or drug of abuse that has effects similar to those, or any instrument, device, or thing that can be used to administer them or prepare them for administration, unless you have a lawful prescription, and that does include medical card. You can't have a medical card, marijuana medical card, I should say. Other than that, you have to have a lawful prescription, which means a DEA prescription. Medical marijuana does not apply. You are to submit to drug testing when and as requested by the probation department or your treatment team. You are not to associate with anyone who might have been a co-defendant or has a criminal record, a member of a gang or a criminal group, or a person who has a past or good future. It forces you to commit a criminal offense or violate these conditions unless that's proved in writing. That includes any family members that may fall within that definition unless you're living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation, a common marriage type of relationship with another person without written permission. You must report any conviction, arrest, citation, or other charge violating the law not later than the day after that occurs. You must provide your supervising officer financial information records for your ability to pay any restitution fees for costs of your review. You're referred by your supervising officer or other probation department or treatment team for any evaluation for further treatment, counseling, educational programming, or other type of programming. Beyond that, the specific order by the court. You're to submit to that. If there's a recommendation for programming, you're to enroll in and successfully complete that. You pay the court costs of this action. Make payment arrangements with the clerk. You're to comply with all conditions set forth in the drug court docket that you have provided. And you must comply with your treatment plan as recommended. And right now that includes the residential treatment that's recommended, plus transitional care afterwards. Now, by being placed on community control rather than being sentenced to prison, you're legally consented to serve without a warrant of your person, your residence, your vehicles that are owned by you or used by you, or any other property or place where you're found, which is under your control at any time by any officer of the probation department. There'll be no fine or no suspension of driving privileges. You're also ordered to pay court costs in addition of your community control. It's also ordered as a substantive order. You don't make payment arrangements to do that. The clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work. In an hourly rate set by the court, each hour you work will reduce your credit by that amount until paid for. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a notice at the court. You'll be given a copy of that. There will be a hearing conducted. You'll be entitled to have an attorney at that hearing. If the outcome of the hearing is that you have failed to comply, then at that time the court could terminate you from the drug court docket, terminate your community control, and sentence you to prison for a period 6 to 12 months and fine you $2,500. If that occurs, once you complete the prison term imposed by the court, the law provides that as part of that sentence, the adult parole authority could make a decision. It's optional. It will be up to them to put you under post-release control supervision, meaning to be supervised by a parole officer in the terms they set, for up to 2 years. And if during the period of time you're being supervised, they determine that you have failed to comply, then they can return you to prison, even though you served the entire term set by the court, for an additional period of up to 6 months for one or more violations. However, if you commit a new felony, and an additional never sentence a judge in a new case proposed appointing that judge would also sentence you in this case, committing that violation while under post-release control in this case for an additional period of 1 year, or whatever time left on that period of post-release control, whichever is greater. If that occurs, that would have to serve in second release sentence in the new case. All right. Is there anything further from counsel? All right. And the treatment team will be in touch with you, Mr. Purcell. Thank you. You can go ahead and log off whenever you want to. All right. Let's see. Now we have Ms. Silverbrand back in jail. So. All right. Okay. We're back on verification number 21 CR70 Stable High versus Lacey K Health Brand. We lost our connection there at the start of the last hearing, so we were recessed until that connection should be reestablished. Now, Ms. Hildebrand, this is a sentencing hearing. You have previously pled guilty to burglary, which is a second-degree felony. The matter was referred for a pre-sentence report. The court did receive that and reviewed the same. And each of the attorneys had an opportunity to review the summary.
Yes, sir.
All right. Now, Ms. Witch, you and I remember to cover this earlier, so if you and your client both agreement to have this hearing by Zoom rather than in-person appearance in courtroom.
Yes, we are.
And you're agreed to that, Ms. Hildebrand? Okay. All right. I have reviewed the pre-sentence report, so I'll hear any statements that the state would have regarding sentencing.
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. We start by noting this offense carries a presumption that a term of incarceration is necessary. Also, this defendant has a prior felony drug conviction that was in that case, she was initially given under treatment at community control STAR, and within about 4 months of that order, she was unsuccessfully discharged from STAR, had her probation terminated, and was sentenced to a term of incarceration. Also, looking at her behavior while on pretrial supervision in this case, she was not reported to probation for a PSI interview. She failed to appear at her sentencing hearing back on October 21st. So given all that, I think it's clear that she's not amenable to community control and would ask that the term of incarceration be imposed. Thank you.
Is there any restitution? The plea agreement said restitution would be paid. I don't see any figures on that.
There's no restitution.
All right, thank you. All right, Ms. Witt, on behalf of the defendant.
Yes, Your Honor. As Mr. King already stated, it's quite evident that Lacey has not been doing well with like this case. She does have significant mental health and addiction problems, which is the root of this whole case. Actually, it affects the case when she entered the home of the garment person. It was not her intent to do anything badly or maliciously. It was because she was high and did have mental health problems and thought she or her children calling for her. So I think that prison is not going to be helpful for her. It'll be more helpful for her to serve time in STAR with a suspended sentence and time hanging over her head, so that should she violate, she can immediately serve incarceration. So we ask the state for her to start treatment.
All right, anything you'd like to say, Ms. Hildebrandt?
Yes, I don't want to make excuses. As this was said, I did enter into the bar, not trying to harm anyone, but I still struggle with her his pride. And I'm just constantly hearing, I still don't find that the student has relapsed. I still never experienced your journey. Just after this night, that's all I can. I understand it's STAR, also I'll get myself off. And then I move on and bring out the struggle with it. So, yeah, I go, and then put on that, you're why. And all that, the big time that they walk.
Well, Ms. Hildebrandt, I see here that you had a previous opportunity to police STAR back in 2012, and you were discharged without completing it at the time you went to prison. You've had mental health help apparently. I see here that you were treated by Southlake Valley Health and discharged successfully July 6th of this year. You say you're off your medication, so you did have your medication, and this actually happened back in April, I guess, so I'm not sure when. Well, that's your fault for being on your meds, not maintaining your treatment plan. That is solely on you. And the problem I have here is that this isn't a situation of you just having mental health issues and or addiction. What you're doing is you're breaking into people's homes. And I know this was barn, and they were living in it. They had living quarters in there, and they were staying there because they were doing some remodeling. And so we broke into someone's home and went through it, and that's an extremely serious matter. And I can tell you that if I had ever given anybody community control on a burglary involving a home invasion with people present at the home or thereabouts, I don't recall, and not going through this case. So it is the judgment of the court that should be, hereby sentenced to the United States Supreme Court for Women at Marysville, Ohio, for a period of 4 years as a minimum sentence. And under the law, because it's a Section 3 felony subject to the Reagan Codes law, that sentence could be extended by the Department of Corrections, Rehabilitation Corrections, up to 1/2 of that sentence. So that could be, you could serve up to 6 years as a term. But the minimum sentence being imposed by the court is 4 years. Now, according to, as of October 13th, you have 39 days. When were you picked up by the sheriff's office on this case, Ms. Brown? 23rd of what? November? Oh, I'm sorry, December. Okay, it's not in the file yet. Okay, December 23rd. So we have 12/23 until today is the 28th. So that's an additional 5 days. So you have 44 days in jail time. Correct? No, it's not mandatory. other than you're going to prison, but it's the minimum sentence. It's not mandatory, it's minimum. So you are eligible for judicial release. I wouldn't get my hopes up, but you can file for judicial release. It's not one of those where you have to serve every day period. But the minimum sentence is 4 years, and then once you serve that, if the Department of Corrections feels you should serve more, they could add up to 2 more years to that for the matter. Now, upon completion of the prison term, then you will be put under post-release control supervision by the adult parole authority for a period of 3 years. That is mandatory. And that means you'll be supervised in the term set by the parole authority by a parole officer. And if they decide that you have violated those conditions during that 3-year period, they can return you to prison even though you served the entire term set by the court and any additional period that the Department of Corrections ordered, for a period of up to 9 months for any one violation, up to a maximum of half of the term that was imposed by the court for all violations. However, if you commit a new felony while under post-release control supervision, then an additional whatever sentence the judge in the new felony case would impose upon you, that judge can also sentence you for committing that violation while under post-release control in this case to an additional period of 1 year, or whatever time's left on that 3 years of post-release control, whichever is greater. That period that will be served consecutively to the sentence in the case. Now, you're also ordered to pay the court costs, which judge will grant an execution order. If you fail to do that, the court will collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do service once you complete your prison term, not while in prison, but once you get out in this county, and the court will give you credit for each hour you work in an hourly rate determined by the court. And each hour you work will reduce your judgment by that hourly rate until it's paid. All right. Is there anything further from counsel, Mr. King? Ms. Witt? All right. Thank you. All right. Last case then will be State of Ohio versus Katie Marie Freed. All right, case number 21 CR 177, State of Ohio versus Katie Marie Freed. And you are Katie Marie Freed, appearing there on the screen that has Crystal Wade, or Wade, whichever way she pronounces it, on the screen.
Yes, Your Honor.
All right.
Yes.
Okay, this hearing is being conducted by Zoom. And which facility are you at, Ms.
Lingoff.
Okay, Lingoff, all right. All right. All right. Hearing by Zoom as well. Her office is the attorney for the defendant, Daniel Witt. Hearing on behalf of the state's attorney, Adam King. Ms. Freed is charged with aggravated possession of methamphetamine, a fifth-degree felony. Now, this hearing is being conducted by Zoom because of COVID-19 concerns, and Ms. Witt and your client are both agreeable to waive their first in-person presence in courtroom and hearing conducted this hearing by Zoom.
Yes, sir.
Okay, and you're agreeing with that, Ms. Freed? I think you heard?
Yes.
Okay, thank you. All right. Now, Ms. Freed, I've been presented with a plea guilty form, which is a 3-page form that the prosecutor's office prepared and fills in as applicable to your case. I'll hold the first page up so you can see if you recognize the form. It says plead guilty. You see your name there, your case number?
Yes, sir.
All right. On page 3, there are signature lines, and about a third of the way down, there's a sentence that says, I enter this plea voluntarily. Right below that, there's a line with signature defendant under there. It looks like Katie Freed's signature. To me, I'll hold that up, and is that by my finger?
Yes, sir.
Your signature. All right. When did you sign this, Ms. Freed?
Last week.
And did you sign it there at Lingoff, or were you with your attorney to
Yes.
sign? Okay.
Lingoff.
All right. And did you go over this and read it thoroughly before you signed it?
Yes.
And did you talk with your attorney about this and have her explain everything to you before you signed it?
Yes, sir.
Do you feel that you've had enough time to fully consider this matter before making this decision to sign this document?
Yes, sir.
You haven't been pressured or rushed in any way?
No, sir.
You're entering into this agreement, you signed it voluntarily.
Yes, sir.
All right, now the agreement states that you are going to plead guilty to the charge in the indictment of aggravated possession of methamphetamine under 2925.11 of the Revised Code, a 5th-degree felony. It further states on page 1 that you understand that the maximum possible prison term for this is 12 months. If prison is imposed, the minimum would be 6. There could be a fine of up to $2,500. There could also be a license suspension between 6 months and 5 years. You understand that?
Yes, sir.
Now, Ms. Creed, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony in any jurisdiction?
Just the one right now with you.
Okay, that's just pre-trial supervision, but you're not being convicted and on probation for another case.
Nope.
Okay. Under the law, Ms. Creed, if you are convicted of this offense and if you are sentenced to prison, once you complete that prison term, it's possible that the adult parole authority can put you on what's called post-release control supervision for a period of up to 2 years. What that means is you'll be supervised under the terms that the parole authority sets, because the judge has nothing to do with that. And if they determine that you have failed to comply, then they could return you to prison even though you served the entire term that was ordered by the court for an additional period of up to 6 months, which would be half of the maximum prison term for one or more violations. But if you committed a new felony offense while you were being supervised, then an additional whatever sentence could be imposed upon you for committing that new offense. That judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time will be left on that 2 years of post-release control, whichever is greater. And if that happens, that sentence would have to be served after the other sentence was served, the second.
Yes.
Do you understand that?
Yes, sir.
Right now, I'm not required under the law to sentence you to prison if you plead guilty, or if you're found guilty after a trial. I can impose what's called community control, or what most people know to be probation. And what that means is instead of being sent to a prison facility, you would be put under supervision of the probation department under terms that are set by the judge for up to 5 years. Now, if during that period of time the probation department felt that you were not complying with those rules and conditions, they would have to file written notice of that with the court. They would have to give you a copy of that telling you what it is you're charged with. And then you would be entitled to have a hearing on this matter and also be represented by an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then send you to prison for 12 months and fine you $2,500. Do you understand that?
Yes, sir.
Right? Now, the charge in this case alleges Ms. Mr. Creed, that on or about April 11, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine in violation of Section 2925.11 of the Ohio Vice Code, which is the charge of aggravated possession of methamphetamine, 5th-degree felony that I just described for you what the sentences are. Now, do you understand what it is you've been charged with, what the state said you did, when, or how they let you get?
Yes, sir.
And you understand the possible penalties if convicted of this offense?
Yes, sir.
You discussed the nature of this charge, the evidence in the case, the possible legal issues in the case, the possible defenses you can try to raise in trial, and the possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs at the present time?
Yes, sir.
And what do you take those for?
Mental health, sleep,
Okay.
and night terrors.
All right. Now, are any of those medications interfering with your ability to understand what we're talking about here today, or to convey your thoughts accurately?
Absolutely not.
Okay. Now, have any threats been made against you to get you to plead guilty here today?
No, sir.
Now, on page 2, there's a couple of lines that have been printed in bold and underlined, and part of the last sentence has been stricken through, meaning it doesn't apply. So I'm going to read that portion that applies. Defendant shall enter plead guilty to the indictment, state defense, joint recommended community control, and defendant be referred to record. Now, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
All right, now, under the law, Ms. Creed, the matter of sentencing is up to the judge, not the parties. So even though there's an agreement that you plead guilty and get a certain sentence, basically community control or probation, and be referred to drug court, once I've heard all the information presented to me in the sentencing hearing, I don't have to follow the recommendation. I could decide that's not the correct sentence. You should be sentenced to prison, you should be fined, you should have your license suspended for 6 months to 5 years. That could be the sentence instead of probation or community control. Do you understand that?
Yes, sir.
And now, as far as drug court is concerned, the drug court is a choice a person that's going to be put on community control chooses, because the court doesn't force people into drug court. Drug court is a program that's based upon the person's willingness to volunteer to be in the program and to accomplish the goals, which are to focus on treatment and thereby keeping that person from committing any new crimes or violations and going to prison. Whereas community control is simply focused on keeping you out of prison, hoping you can stay clean and do those things, but it's a whole different approach. So you will have to talk with Ms. Sturgill, who's actually present there, at least on my screen, she's right next to you. She's a drug court coordinator and the probation department, and they'll make recommendations. And also, they have to evaluate you to make sure that you meet the criteria for the program. And then once they've made that determination, then I will make a final decision and decide whether or not you should be accepted in the drug court if I give you community control. Do you understand that?
Yes, sir.
Okay. Now, do you hold any license or certification from any state agency for any kind of a profession or occupation? Nursing assistant or SDNA or anything like that? Okay. Right, now you have certain constitutional rights, misunderstand Ms. Creed. Before it can accept the plea of guilty from you, first of all, you have the right to have counsel. Ms. Woodson is appointed to represent you. Now, I didn't appoint her simply to work her case out, but to provide any representation and defense against these allegations that could be available under the law. So if you decide you don't want to plead guilty, that you would like to defend against this charge, she will continue to represent you and defend you, including a trial if that's what you decide you want. Do you understand that?
Yes, sir.
Right, now under the Constitution, you have a right to have a jury trial in this matter. Ms. Creed, in which 12 people will be selected from a group of citizens who live in this county, who are summoned for jury duty under your trial date. After those 12 jurors are selected, the evidence will be presented, they'd be told the law by the judge, and then they will decide by a unanimous verdict, meaning that all 12 of them have to agree on whether the state proved your guilt on the charge. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, and that means to give up your right to have a jury trial, and in that case, you would have what's called a forward bench trial. That means that instead of a jury hearing the evidence, it would be the judge who hears the evidence. The judge would apply the law, and the judge would be the one who would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come to court to testify on your behalf, just like the state. What that means is that if you have witnesses you want to have testify, then you can ask the court to issue a court order, that's a subpoena, and that would make those people come to court to be available to testify if you decided to follow them, even though they didn't want to be here or be involved. That's the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Creed, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's your decision totally. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one can even talk about it except in one situation. That is, if there's a jury trial, you don't testify, then the judge does instruct that jury in your case, that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio, every essential element of the offense charge. What that means is the burden of proof isn't on you to prove you're not guilty simply because you've been accused by being indicted by the grand jury. In fact, under the law, you don't have to present any evidence in your defense at all at trial. You may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof will remain upon the state of Ohio prove your guilt on every essential element of the offense charge and prove beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, originally entered a plea of not guilty. Discreet, that plea denied the allegation in the indictment, denies you committed any crime, and it exercised or invoked all of the rights that I have just described. Now, if you change your plea from guilty to not, from not guilty to guilty, then that is the opposite of the not guilty plea. The not guilty plea denies that you committed any crime. The guilty plea says what you've alleged in the indictment is, the state's alleged is true, it's a crime, and I committed that crime. And that plea of guilty waives or gives up all the rights that I've described for you here this afternoon, except the right to have an attorney. You always have a right to have your attorney no matter what your plea is. Full that exception, your plea of guilty waives and gives up the right to have a jury report for you. It waives gives up the right to confront witnesses against you and to cross-examine for your attorney. It waives gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It waives gives up your privilege against self-incrimination because you're saying you're guilty, and that's what she finds you guilty. It waives gives up your presumption of innocence because you say you're guilty, then the state doesn't have to prove you're guilty. The plea of guilty also subjects you to be sentenced immediately by the court, and it waives and gives up any right to file an appeal that you think you may have had up until this point in the case for any alleged violation of your rights. Now, if I should sentence you to the maximum sentence, or under certain limited circumstances, an appeal would be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And Ms. Creed, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties?
No, sir.
Do you understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
Do you understand?
Yes, sir.
And again, you understand the recommendation on the sentence is not binding on the judge.
Yes, sir.
Any questions about the constitutional rights I've explained to you today?
No, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
Do you understand that?
Yes, sir.
Is there anything you need to speak with your attorney about before we go any further here today?
No, sir. I already talked to her.
All right, do you have any questions of me about anything that I've explained to you here today?
No, sir.
All right, then is it your decision to withdraw your not guilty plea and voluntarily enter a plea of guilty to the charge and the indictment pursuant to the terms of this plea agreement that we've just gone over?
Yes, sir, Your Honor.
All right, then as to the charge which alleges that on or about April 11, 2021 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term of between 6 and 12 months, fine of up to $2,500, possible license suspension of 6 months and 5 years. How do you plead?
Guilty.
All right, thank you. The court finds that on this day in open court, defendant was advised of all constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal ruling. Please accept it or reply. Defendant is found guilty of the charge as set forth in the indictment, fifth-degree felony. Matter is referred for a pre-trial, pre-sentence report to the probation department, which will include the assessment for substance abuse and/or mental health assessment, based upon which the defendant's representative here, she's already ruled those. Case is referred to the drug court as well for evaluation. We will set the sentencing hearing for February 17 at 1 p.m. The bond will be continued. Continue to stay in the off and apply whatever treatment is recommended. If you complete the residential program, then I'm sure there'll be some kind of residential transitional plan, so you'll need to continue to apply with that. This Sturgill, you want her to call you, or you're going to call, or have Mr. Polk call Lake Off to set up the interview?
Yeah, we'll reach out and set it up.
All right, thank you. Then Mr. Polk and the probation department, Mr. will be in touch with you then. Anything further?